Abubakar Malami, the Attorney General of the Federation and Minister of Justice, sat down with ARISE News correspondent Christian Ogodo to address the concerns raised by the Nigerian Governors Forum on its directive sanctioning the payment of $418 million to private consultants over the Paris Club loan refunds. Now we'll be airing the full interview with Malami, in which he also spoke on other issues of national importance. Here it is.
Thanks very much, Honorable Attorney General of the Federation and Minister of Justice, Abubakar Malami, SAN, for speaking to us exclusively on ARISE News. My first question will be the controversies surrounding the issue of the Paris Club Fund refund to some consultants to the tune of $418 million. Some of the governors of the Nigerian Governors Forum feel that you've compromised and you've put the interests of Nigerians at risk.
Well, I think the proper approach for the purpose of understanding the true position of things as far as the Paris Club refund issue is concerned is for you to understand that it's an issue that predates the administration of President Muhammadu Buhari. Sometimes, as far back as 2013, there was an engagement by Algon and the Nigerian Governors Forum of certain consultants that were engaged by the two for the purpose of recovering certain amount of money relating to Paris Club refund. And these consultants that were engaged had indeed delivered, and then fundamentally they were not paid the services, the fees for the services they claim to have rendered, on account of which they approached judicial system for determination of their rights and indeed enforcement of their fees. Now in 2013, parties, I'm talking of the Algon and indeed the Governors Forum, came together, agreed and submitted to a consent judgment before a court of law in 2013. That consent judgment is what gave rise to the liability in contention as we are talking today. So in 2017, 2019, the federal government was approached by these consultants for the purpose of payment of their respective professional fees. The federal government approached Governors Forum and Algon, and they collectively wrote to the federal government and conceded to the position that the consultants have indeed provided the services and they were ready and willing to effect the payment. But the point of interest arising therefrom is the Governors Forum and Algon wrote to the federal government conceding that payment should be deducted from their monies and then should be effected to the consultant. So in 2016, 2017, these deductions were carried out at the instance of the Governors Forum and at the instance of Algon. Now, that was the situation on the ground. But when eventually these claims were made, the federal government, under the office of the Attorney General of the Federation, felt the amount that the Algon and the Governors Forum had agreed to be paid to these consultants was in fact a very huge amount of money. And the federal government became suspicious of what the Governors Forum and indeed Algon were up to, taking into consideration that what was in contention were the services. So the federal government wrote EFCC and DSS seeking for the verifications of the veracity and authenticity of the claims in one hand, and indeed the judgment that gave rise to the claim. A point of interest arising from that is that the EFCC, DSS wrote to the office of the Attorney General in confirmation of the liability. And even at that, the federal government, because the federal government was made a party in the suit that was instituted by the consultant. And the implication of making the federal government a party is that the federal government could as well be liable and execution could be levied against the interest of the federal government. So on that note, the federal government took steps to approach the Governors Forum and ALGO for the purpose of having their take as far as this liability is concerned. I'm happy to report that the governors, as of 2017, individually wrote in confirmation of admission of liability, and the same thing with governors, with ALGO. So this is the background. One, that there was a claim in respect of which the federal government was made a party, claim by consultants against ALGO and the Governors Forum. Two, the federal government took steps by way of verification of these claims and indeed wrote to EFCC and DSS seeking for background checks to ascertain that nothing funny is taking place between the ALGO, Governors Forum, and the consultants as far as these claims are concerned. Three, when eventually such verifications was confirmed, out of further abundance of caution, the federal government took steps to demand for confirmation in writing from ALGO, demand for confirmation in writing from the governors. Governors individually wrote to the effect that they were liable. ALGO wrote to the effect that they were liable, and eventually these payments commenced as far back as 2016. Now, nothing untoward happened thereafter until perhaps of recent, when the governors wrote seeking to kind of avoid liability. The implication of that, taking into consideration that the federal government was indeed sued as a party, was that at the end of the day, the liability will be placed at the exclusive door steps of the federal government, while in actual fact, this is a liability that was incurred by the Governors Forum. This was a liability admitted by the Governors Forum. This is a case in respect of the Governors Forum and ALGO conceded to a judgment by way of submitting to a consent judgment before a court of law. So what I am laboring to state in effect that, one, the engagement that gave rise to this liability was an engagement that was indeed that was factored by ALGO and Governors Forum. Two, arising from such liability by way of creating a contractual obligation, parties submitted to the jurisdiction of the court arising from a case instituted by consultants against the Governors Forum and against ALGO, and the parties submitted to consent judgment. Three, that even after a consent judgment was obtained in 2013 before the coming in place of this government has taken it further by way of conducting due diligence to ascertain the liability and demanded for investigation from agencies of government, inclusive of the EFCC and DSS, and the claim of the consultants in respect of which the Governors Forum and ALGO had submitted to judgment, a consent judgment before a court of law, was ascertained and confirmed to be genuine. And then three, the governors have indeed provided an indemnity, a letter of commitment to the Office of the Attorney General, to the federal government, that they were indeed liable. The same thing with ALGO. And then for over and above all this abundance of caution, payments has been effected over time without raising any objection on the part of the ALGO, on the part of the Governors Forum over time. So it is indeed amazing that the governors are now belatedly, after having serviced the same claim for over a period of 4 or 5 years, are now belatedly turning around to raise objection in respect of the payment, even when, one, they have consented on their own to a judgment which was entered in 2013 before this government came in place. Two, they have been effecting periodic payments in respect of the same. Three, they have provided individual indemnity and commitment that this payment should be effected over time. So that is the antecedents that I think is of interest as far as this matter is concerned. But for the office of the Attorney General, one thing that I think should be made clear as well is the fact that the responsibility of the Attorney General is to provide the necessary protection to the federal government. And I cannot be sitting here as the Attorney General and allow the federal government to be exposed to a liability, a third-party liability, a liability incurred by Algon, a liability incurred by the Governors Forum, and then in respect of which they have submitted to consent judgment, in respect of which they have provided an indemnity and a consent for such deductions to be made, and in respect of which deductions has been made over time without objection, only for them now to turn around to create a situation that will expose the federal government to liability, even when it was indeed their liability that by their own showing, by their own admission, by their own commitment, they have been servicing and they have conceded to.
Honorable Minister, will you say the governors are forum shopping?
Well, generally speaking, as I have stated, arising from my earlier submissions, government is this is a government that is indeed being very cautious in whatever it does, and this is a government that covers the field in terms of due diligence, as far as claim and counterclaim relating to any liability that is placed at its doorstep. So what I am trying to say in essence is the government will do whatever it takes in terms of avoidance of liabilities generally. For the case of on the issue of forum shopping, truly it is the best word to characterize what the Governors Forum and Algon is doing in the circumstances of the Paris Club arrangement. Why? Because one, they have originally submitted to a consent judgment. Two, arising from the consent judgment, orders were made, inclusive of garnishi orders and orders of mandamus. And then three, they have indeed conceded to the judgment by way of making periodic payments of the liability arising therefrom. So if after all this, conceding to judgment in 2013, effecting periodic payments and associated submission to liability, the Governors Forum and indeed the Algon turns round to approach the court, then it certainly is a case of forum shopping in the sense that it is a clear case of an abuse. You cannot be submissive to a consent judgment. You cannot, arising from the consent judgment, be making payments of the liability on account of which the consent judgment is entered, and then simply turn around to equally approach the court for the purpose of denial of a liability about 10 years thereafter. This is a judgment that was entered in 2013. And then today, in 2021, someone is coming around to claim that he is denying a liability, even when his opportunities for appeal and associated privileges associated with this, setting aside the judgment, were there and were at no point exercised.
How would you react to the allegations or insinuation that you have a special relationship with the consultants, particularly when you look at the humongous amount of money involved here?
Well, I am a lawyer and not a contractor, and neither am I a consultant. And one thing of interest, if there is any insinuation of relationship, it should be placed at the doorstep of the governors and the Algon, who have over time first engaged the consultants, two, conceded to consent judgment, three, arising from the consent judgment have been paying the professional fees. So if there is any insinuation of a relationship that can justifiably and logically be made, it should be an insinuation that should logically be placed at the doorsteps of the governors and indeed the Algon, who in the first place engaged them, who in the second place conceded to a consent judgment, who in the third place have been paying over time. And for your information, that judgment was a 2013 judgment, even before the Abubakar Malami as the Attorney General of the Federation was appointed, even before the government of President Muhammadu Buhari came in place. So apparently, if you are looking for a relationship, the better place to, the better point to place it is at the doorsteps of who? Of the governors, doorsteps of who? Of the Algon, who had indeed demonstrated a clear understanding, both contractual and business-wise.
Honorable Attorney General, you want to tell us about the state of the PNID case in a London court. We know that the federal government had two victories, one to set aside the judgment of about $10 billion against it, and another $200 million or so to be deposited in cash, which the government won too. What is the state of that case now? And is the government hopeful of winning that case?
On the case of P&ID, you know, in a nutshell, it has been a success story all through. This is a case in respect of which perhaps an arbitral award around the sum of $10 billion was made against the interest of the federal government. And then nothing was done by the previous administration until after the right of the federal government to appeal against the judgment had elapsed. And then the enforcement of judgment was being contemplated. Many years thereafter, which is unprecedented, the federal government filed an application for setting aside the enforcement. And the first success recorded arising therefrom, the order was made for the stay of enforcement of the judgment. And this is unprecedented, taking into consideration that, in fact, even the time within which we were expected to appeal had elapsed. And then further, the court ordered that we should pay 200 million pounds as a condition for stay of execution of the judgment against the interest of the federal government, its assets and economic interest. But then again, we challenged the order for the payment of the $200 million, and that order, that our challenge, our objection to a deposit of physical cash was equally sustained, a second reason for celebration as far as the case is concerned.
Okay, my next question will center around the Sunrise Power and its litigation against the federal government over disagreements on the execution of the Mambila hydroelectric power project in Taraba State. You want to tell us, have you reached a settlement, has the federal government reached a settlement with that company?
For the Sunrise, perhaps one good information or perhaps the calls for celebration that I wish to present for your consideration is the fact that Sunrise had indeed withdrawn its pending arbitral proceedings in respect of which it was claiming against the interest of the federal government an amount within the region of around $1 billion. So as it is, the only impediment to Mambila project, which had been the pending litigation that constituted an impediment that stopped the investors from investing in Mambila, had been effectively displaced with the withdrawal, with the discontinuation of the arbitral proceedings by Sunrise. So the information that calls for celebration is the fact that there is any pending impediment relating to Mambila project with the discontinuance, with the discontinuation of the Sunrise proceedings in Paris.
Recently, the president said in the broadcast that a member of the National Assembly is the brain behind secessionist agitation in the country. Why is the government not unmasking the said legislator and others who are sponsoring terrorism or, as the case may be, making the country insecure?
Well, you see, the government has been unmasking. Starting with the unmasking idea you put across. The government is unmasking because, as you rightly know, first, Iboho is charged. Kanu is charged. Over and above that, investigations, as has rightly been disclosed by the Attorney General, with particular regard to the funders and financiers of terrorism in Nigeria, is ongoing. So at the appropriate time, which is indeed when the investigations are concluded and these parties are being presented to court, they will certainly be known. But then the Nigerians are entitled periodically to be informed as to what we are doing.
Okay. Honorable Minister, let us look at another controversial issue, is that of the secessionist agitators. Sunday Igboho is already in court. Nnamdi Kanu is being charged to court as well. He's been charged to court and has been appearing in court. Is the federal government not thinking of a political solution to resolving this crisis, particularly as some Nigerians are advocating that a political solution should be reached to resolve the matter?
Generally speaking, as far as security situation is concerned, as far as governance is concerned and administration, you cannot rule out all possibilities. But crime is a crime. When there are criminal undertones associated with certain conduct, you cannot take away the right of the government to take steps with particular regard to ensuring that the people that are in one way or the other operating in breach are brought to book. But they want
Boko Haram members are being pardoned and the rest.
Sorry?
Boko Haram members have been pardoned, repentant and the rest.
Well,
committed crime.
No, everybody that commits a crime, apparently there has equally been a program of amnesty before now. So it's not about Boko Haram or perhaps the Niger Delta militant. Generally speaking, that is why I am telling you that no possibility is outruled. But then there has to be an approach for the government to consider. So I cannot be preemptive in telling you clearly and outrightly that reconciliation perhaps is being considered without an approach being made. It is the approach being made, if at all any is made, that we will look into for the purpose of looking at its weight, the authenticity of it, the good faith associated with it, and then perhaps bring about the considerable factors related to the negotiations or otherwise. So it is not a conclusion that one can outrightly make without juxtaposing associated facts relating to the reconciliation. You cannot operate a reconciliatory approach in the blues. It's never a one-sided. There has to be an approach and then a counter consideration. So no approach in that respect is on table for consideration yet. So we'll get to the bridge, we'll cross the bridge when eventually we get to that. When perhaps a kind of request is made, we'll consider.
Abubakar Malami, senior advocate of Nigeria, has been our guest on ARISE Special. Thanks for watching. I am Christian Ogodo.